Getting out of a non-compete agreement can be quite challenging. There are a few cases where you can actually get out of a non-compete agreement, but in most cases, it is good to have a look at the agreement and see why it could not be compliant any longer. So today I'm going to go through some of the reasons that the no compete agreement could be non-compliant anymore. So without further ado, let's check them out. Okay, so the first thing we're going to address here is employer breach. If an employer failed to fulfill any obligations under that contract that was agreed upon, the employee, being yourself, may be released from the obligations within the no compete. For example, if the employer didn't pay the employee's compensation, and in a situation where there were no insurance requirements met. Also, if there's an unreasonable time period implemented here, a non-compete agreement for less than 6 months is usually considered valid, while one for more than 2 years would be considered invalid. So that's another reason. You also have the legitimate business interest. So if the employer is trying to enforce the non-compete against an employee for whom it is not in their legitimate business interest, for example, this could be, it's unlikely that the employer would have a legitimate interest in enforcing a non-compete agreement against a low-level employee. So then also jumping into the publicity available information. So if the confidential information is readily available to the public in this situation, and public health or safety. If the non-compete would not serve the public's health or safety, this may apply to maybe doctors, nurses, and others in specialized health situations or even in scientific fields. And then the last one that we've got listed here is a fired without cause situation. So if you were fired without a cause, this could enforce that the non-compete will not be applicable. I hope this information was helpful. Thanks for watching.